Has the probate process seemed to be completely stalled? Maybe months have gone by and you're getting little to no information. Calls aren't being returned, documents aren't being shared, assets haven't been distributed. If you're a beneficiary, it's natural to wonder, can I do anything if the executor isn't doing their job? The answer is yes. In Wisconsin, the executor, which is officially called a personal representative, has legal responsibilities to the estate and to its beneficiaries. If they're failing to perform those duties, there are steps that you can take. I'm Paul Zimmer, an attorney with Zimmer and Rens, and in this video, I'll explain how to replace an executor or personal representative in Wisconsin, when court intervention may be appropriate, and what you should do before taking legal action. So step one is to determine whether there's actually a problem. Probate does take time, and that's important to understand up front. There are notices that need to be sent, creditors have to have time to make claims, assets need to be located, sometimes tax issues need to be addressed before distributions can ever happen. So a delay doesn't automatically mean that something is going wrong. What you should be looking for is a pattern. If a personal representative won't communicate or won't do their job, any interested person, including a beneficiary, can file a petition with the probate court. The court can issue an order to show cause, which requires the personal representative to appear and explain why the required documents haven't been filed or why the duties haven't been performed. In many situations, that alone is enough to get the estate moving along again. Removal is usually not the first option, but there are situations where unfortunately it becomes necessary. For example, maybe the personal representative is ignoring court orders. Maybe estate funds are being used improperly. In situations like these, Wisconsin courts have the authority to remove that personal representative and appoint someone who's different to finish administering the estate. The replacement might be another family member, a successor named in the estate plan, or it could even be a neutral third party if the conflict has become severe. In some very serious situations, a personal representative might be held personally responsible for losses to the estate that they have caused. This is sometimes referred to as a surcharge action. Not every mistake creates personal liability, however. When beneficiaries suffer financial harm because fiduciary duties are violated, Wisconsin law does provide a remedy. So, when should you be concerned? A good rule of thumb is this. If a probate has been sitting idle for an extended period of time, if communication has stopped, and no meaningful progress is being made, it might be time to seek legal guidance. Most personal representatives work hard to fulfill their responsibilities and honor a loved one's wishes. But when an executor stops communicating, ignores their duties, or puts estate assets at risk, beneficiaries are not powerless. Wisconsin probate law provides the tools necessary to compel action, to request accountability, and when necessary, to replace a personal representative who's not doing their job. At Zimmer and Rens, we help families navigate the probate and estate administration process and disputes. Personal representative issues are something that we handle throughout Wisconsin. If you're concerned about how an estate is being handled, call your friends at Zimmer and Rens to discuss your options. And for more videos on probate and estate planning and Wisconsin inheritance matters, be sure to subscribe to our channel.